Greetings and welcome to Courts This Week on Live Law. I am Tanya Pandey, and every week I bring the crux of the latest judgments from courts across India for you. If you want to stay updated, subscribe to Live Law and click the bell icon to get notified of every new video. Let's begin today's episode with judgments from the Supreme Court. The Supreme Court on 24th September set aside the observations in the Madras High Court's order, which said that the reservations for economically weaker sections in the NEET All India quota can be implemented only with the approval of the Constitution Bench of the Supreme Court, that is examining the correctness of the 103rd Constitutional Amendment, which provides for economic reservations. A bench of Justices D.Y. Chandrachud and V.V. Nagaratna was hearing an SLP filed by the Union of India against the Madras High Court's observations and held that such observations were unnecessary. The bench said that the Madras High Court was considering a contempt petition seeking implementation of OBC reservation in NEET All India quota, and hence the observations on 10% EWS quota amounted to a transgression of its jurisdiction. While noting that the Defence Forces have charted a course forward for induction of women in the National Defence Academy, the Supreme Court has observed that the issue of admission to girls in Rashtriya Indian Military College has to be addressed and cannot be postponed. A bench of Justices S.K. Kaul and B.R. Gavai has directed the Union of India to address the issue of induction of women to RIMC and Rashtriya Military School at par with issue of induction of women to NDA and file an affidavit before the court within 2 weeks. In similar news, the Supreme Court has refused to vacate its interim order allowing women candidates to take the NDA entrance examination scheduled for November. The bench further noted that it was informed that the UPSC has still not issued the corrigendum allowing women to participate in the exam and accordingly directed for them to do the same. The Supreme Court has observed that even if an alternate remedy exists, a High Court can exercise its writ jurisdiction if the order of the authority is challenged for want of authority and jurisdiction, which is a pure question of law. In this case, Magad Sugar and Energy Limited had approached the High Court challenging the imposition of Bihar Electricity Act or electricity duty and penalty on the electricity that it was supplying to Bihar State Electricity Board. The High Court had declined to entertain the writ petition on the ground of an alternate statutory remedy under Section 9A of the Act. The Apex Court noted that the petitioner mainly contended that the state government does not have the power to levy tax on its sale of electricity to the Bihar State Electricity Board, and therefore the plea strikes at the exercise of jurisdiction by the government, which can be gone into by the High Court under its jurisdiction. The order of the High Court was quashed and the case was restored for fresh determination by it. The Supreme Court has observed that plea of res judicata can be determined as a preliminary issue only when it involves adjudication of question of law. When a mixed question of law and fact is raised, the issue should await a full-fledged trial after evidence is adduced, the bench of Justices D.Y. Chandrachud, Vikram Nath and Hima Kohli has observed. The court also observed that while a compromise decree in a prior suit will not bar a subsequent suit by virtue of res judicata, the subsequent suit could be barred by estoppel by conduct. A suit under Section 92 CPC is of a representative character, and all persons interested in the trust would be bound by the judgment in the suit, and persons interested would be barred by the principle of res judicata from instituting a subsequent suit on the same or substantially same issue, the court added. The Supreme Court has observed that prayer for reference to arbitration under Section 11 of the Arbitration and Conciliation Act can be declined if the dispute in question does not correlate to the arbitration agreement. The bench of Chief Justice of India N.V. Ramana and Justice Suryakant observed that the Supreme Court or the High Court is not expected to act mechanically merely to deliver a purported dispute raised by an applicant at the doors of the chosen arbitrator. On the contrary, the courts are obliged to apply their mind to the core preliminary issues within the framework of Section 11(6)(a) of the Act. And therefore, even when an arbitration agreement exists, if the dispute in question does not correlate to the said agreement, the prayer for reference can be declined. In a case related to land acquisition compensation, the Supreme Court has approved the deduction of 50% towards developmental costs. Referring to precedents, the court observed that deductions for development is to be made to arrive at the market value of large tracts of undeveloped agricultural land with potential for development. The deduction varies from 20% to 75% of the price of such developed lots. The court noted that the 2003 precedent in the Kasturi case had held that there may be various factual factors which may have to be taken into consideration while applying the cut in payment of compensation towards developmental charges. The Supreme Court on 22nd September rejected an application filed by the Sri Padmanabha Swami Temple Trust to exempt it from the special audit of 25 years ordered by the court last year for the iconic Sri Padmanabha Swami Temple at Thiruvananthapuram. The court said that the special audit was intended not to be confined to the temple and included the trust as well. As regards the second prayer made by the trust to exempt it from the administrative supervision of the administrative committee constituted for the temple, the court said that it requires factual analysis and hence refrained from expressing anything on the second prayer and left the matter to be decided by a competent court. The Supreme Court has observed that the gravity of complaint under the Negotiable Instruments Act cannot be equated with an offence under the provisions of the Indian Penal Code or other criminal offences. The court reiterated that the presumption under Section 139 of the Negotiable Instruments Act would remain until the contrary is proved. Whether there is rebuttal or not would depend on the facts and circumstances of each case, the bench of Chief Justice of India N.V. Ramana, Justices Suryakant and A.S. Bopanna said. These observations were made while upholding the conviction of an accused in a check bounce case. The court, taking note of the background and the time period spent in litigation, modified the sentence and limited it to the payment of fine only. Let us now look at important judgments from the High Courts. The Karnataka High Court has said that registration of a second FIR for the same incident would be hit by the doctrine of sameness and will have to be annihilated, as it would amount to improving the facts of the case in the subsequent complaint on the same incident. Justice M. Nagaprasanna, while quashing a second first information report registered against a Bharatiya Janata Party worker charged in 2018 under sections 504, 332, 353 of the IPC, said, once having registered a complaint on a particular premise of an incident, it was not open to the complainant to have registered another complaint on the very same incident regarding what happened during the very same period. The Kerala High Court on 24th September issued notice to the state on a petition challenging the government order directing to withdraw the suspension of certain officers in the Excise Department who were accused in a custodial death case. Justice P.V. Kunhikrishnan issued notice in a plea moved by the wife of the deceased who had died in excise custody 2 years ago. In a plea, the petition has challenged the withdrawal of the case registered against the concerned officers before the completion of the trial, with disciplinary proceedings pending against them. The state had issued the order in favour of 7 excise officers who are accused in this case. In a significant ruling, the Kerala High Court has held that a compromise of marriage between the parties is not a ground to quash the criminal proceedings against the accused under the provisions of the Prevention of Children from Sexual Offences Act. Justice V. Sharsi, while dismissing a petition under Section 482 of the CRPC, remarked that when the magnitude of the crime is so grave and heinous as such to shock the sense of justice, a settlement between the parties and a marriage subsequently between them are not matters for consideration to quash the proceedings in a criminal case. The Allahabad High Court has asked the Uttar Pradesh government to specify details of the scheme as envisaged under subsection 11 of section 15A of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989, read with Rule 14 of the SC/ST Rules 1995. This particular subsection makes it the duty of the concerned state to specify an appropriate scheme to ensure the implementation of certain rights and entitlements of victims and witnesses in accessing justice. On the other hand, Rule 14 of the SC/ST Rules 1995 talks about the specific responsibility of the state government for providing relief and rehabilitation facilities to the victims of the atrocity. The bench of Justice Jaspreet Singh and Justice Ranjan Roy sought details about whether any such scheme has been framed by the government of UP on the next date of hearing, which is 22nd October. Importantly, During the course of the hearing, the court also observed that there could be no ifs and buts while interpreting the provisions relating to relief given to the victims under the SC/ST Act. While dismissing a plea seeking deferring of by-elections to the Khandwa parliamentary constituency and Prithvipur, Jobat and Rajgarh assembly constituencies, the Madhya Pradesh High Court on 22nd September held that only the Election Commission of India is competent to decide when to conduct by-elections. The bench of Chief Justice Mohammad Rafiq and Justice Vijay Kumar Shukla was hearing a plea moved by the Nagrik Upbhokta Margdarshak Manch seeking deferment of by-polls amid the possibility of a third wave of COVID-19. A further prayer had been made to direct the respondents to conduct the by-elections only after assessing the ground situation of coronavirus in the state. That's all for today. Thank you for being with us. I am Tanya Pandey and you're watching Courts This Week on Live Law. Have a great day.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.